Welcome to this explainer. Today, we're taking a close look at the employment life cycle. Just like any relationship, the bond between an employer and an employee eventually comes to an end. Sometimes it's a nice mutual sunset, and other times, well, it's a sudden messy split. But regardless of how it happens, the law actually dictates exactly how this corporate breakup has to go down. So let's dive right into it.
It's genuinely fascinating how the law frames the way we think about work. You see, a job isn't just some gig that a boss hands you and can just snatch away on a whim. Legally speaking, your job is a constitutionally protected property right. That is huge. It means you are shielded from arbitrary and unjust deprivation. Taking away someone's livelihood? That requires following some really strict rules.
Here's our roadmap for navigating the corporate breakup. First, when employers end it. Second, the due process rules. Third, when employees walk away. Fourth, fighting illegal dismissal. And finally, number 5, the golden years.
All right, let's start with Phase 1. Section 1, when employers end it, the it's you versus it's me breakup.
So an employer essentially has free reign over their business, right? And that includes dismissing employees. Legally, we call this their management prerogative. But, and this is a big but, this right is absolutely not absolute. It has to be exercised reasonably, in good faith, and it can literally never be used just to dodge worker rights. So there are essentially 2 legal buckets for why an employer can end things. Think of it as the it's you versus it's me breakup. On one side, we have just causes. This is the it's you scenario, meaning it involves some blameworthy act by the employee. We're talking serious misconduct, gross and habitual neglect of duties, fraud, or committing a crime against the employer. On the flip side, we have authorized causes. This is the it's me scenario. It's not the employee's fault at all. It's strictly about the business. Maybe it's retrenchment to prevent serious financial losses or redundancy because a role is just no longer needed. It could also be a total business closure or a health issue where a public health authority officially certifies that a disease cannot be cured within 6 months.
Now, there are also a couple of highly specific edge cases we need to talk about. A dismissal can actually happen if a union security clause in a collective bargaining agreement is enforced, provided, of course, there's solid evidence for the union to expel the employee in the first place. And then, there are illegal strikes. This gets messy. If a strike happens despite a direct government order, union officers who knowingly participate, they automatically lose their employment status. Just like that. Regular union members, though, they only lose their jobs if they commit specific illegal acts during the strike or if they knowingly defy a return-to-work order.
Moving on to Section 2, the due process rules. How to break up legally.
Because an employer can't just yell, "You're fired," and point to the door. They have to observe what's known as the twin notice rule. This is absolutely crucial because it guarantees the employee's fundamental right to defend themselves. Here's how it works. Step 1. The employer must issue a written notice that specifically apprises the employee of the grounds for dismissal. After that, the employee has to be given a reasonable opportunity to answer and defend themselves. Only after all that can the employer proceed to Step 2, which is issuing a second written notice formally informing the employee of their actual dismissal.
Now, while that whole twin notice investigation is going on, an employer might put an employee on preventive suspension. The crucial thing to understand here is that this is not a penalty. Actually, scratch that. Let me be very clear. It is purely a protective measure. It's done to protect the life or property of the employer or the coworkers. And the magic number to remember here is 30 days. A preventive suspension literally cannot exceed 30 days. If an employer extends it beyond that without paying the employee's wages, well, that extension becomes illegal and automatically counts as constructive dismissal.
Speaking of which, what exactly is constructive dismissal? Simply put, it's a dismissal in disguise. You can kind of think of it as quiet firing. It happens when an employer creates a workplace environment that is so toxic, hostile, or unfavorable, like hitting someone with an unjustified demotion or a sudden, massive pay cut, that continued employment is rendered impossible or unreasonable. The employee basically feels like they have absolutely no option left but to quit. But keep in mind, if there's no actual demotion, no pay cut, and the employee never actually resigns, then there's no constructive dismissal to claim.
So up until now, we've really only talked about what happens when the employer holds all the cards. But what if the employee is the one who wants to initiate the breakup?
That brings us to Section 3, when employees walk away. Clean breaks versus messy exits.
Basically, there are 2 main ways an employee leaves on their own: a clean resignation versus a totally messy abandonment. Resignation is the formal, voluntary relinquishment of a position. And by law, an employee must serve a written notice to their employer at least 30 days in advance. Now, this 30-day rule isn't just some polite courtesy. It is legally designed to give the employer time to hire a replacement and make sure there's a proper turnover of tasks. In fact, failing to do so can actually make the employee liable for damages. No way, right? On the flip side is abandonment. This is an unjustified refusal to report to work, completely combined with a clear, undeniable intention to permanently sever the relationship.
And this brings up a really fascinating logical caveat in labor law. If an employer tries to claim an employee abandoned their job, but at the exact same time that employee is actively filing a complaint for illegal dismissal, well, that just doesn't make sense. Filing a complaint to get your job back is fundamentally inconsistent with the charge of abandonment. An employee who is protesting their dismissal clearly intends to retain their employment, not abandon it.
Let's look at Section 4, Fighting an Illegal Dismissal, the fallout.
So, what exactly happens when an employer breaks those rules we just talked about? If they terminate someone without a valid, just, or authorized cause, or if they just completely ignore that twin notice due process, it's an illegal dismissal. And let me tell you, the cascading penalties for the employer are heavy. The primary reliefs are reinstatement, which means putting the employee right back into their old job, and back wages, which restores all the income they lost while they were unlawfully dismissed. If the dismissal was done in bad faith, the employer might even have to pay moral and exemplary damages, plus attorney's fees. Now, what if the breakup was so incredibly messy that putting the employee back in the office would just be a total disaster? That's where separation pay comes in. It's granted in lieu of reinstatement when there are what the law calls strained relations, especially for positions requiring deep trust and confidence. Finally, if an employee was dismissed for a totally valid reason, but the employer just forgot to do the twin notice paperwork, well, the employer still has to pay indemnity or nominal damages just for violating due process.
Now, there are also incredibly strict protections for migrant workers. If an overseas worker is terminated without a valid cause, they are entitled to the full reimbursement of their placement fee, and get this, it comes with a staggering 12% interest per annum. On top of that, they are owed their salaries for the entire unexpired portion of their contract. The Supreme Court actually struck down a previous rule that tried to cap this payout to just 3 months, boldly declaring it a violation of due process and equal protection.
Now, I want to make a quick point of clarification regarding corporate bosses. If a company illegally dismisses someone, the corporate directors and officers aren't automatically personally liable to pay those damages out of their own pockets. They are only held solidarily liable if a court specifically finds that they acted with gross negligence, bad faith, or if they actively assented to patently unlawful acts. Often, just to avoid a long legal battle, companies will offer a settlement in exchange for what's called a quitclaim or compromise agreement. But beware here. The law heavily frowns upon quitclaims if the settlement amount is unconscionably low compared to what the employee is actually legally entitled to. For a quitclaim to truly be valid and binding, it must be voluntarily executed, utterly devoid of any fraud or deceit, and it has to be backed by a credible, reasonable financial consideration.
And that brings us to Section 5, the golden years, retirement.
Let's map out the timeline for this. For the general workforce, you can optionally retire at age 60, and you absolutely must compulsorily retire at age 65, provided you've served the company for at least 5 years. But if you work in a physically hazardous job, the rules shift a bit. Mine workers, both underground and surface, can optionally retire at 50, and for racehorse jockeys, compulsory retirement hits at age 55. Also, employers can actually set an even lower retirement age in their policies, as long as the employees voluntarily agree to it and the benefits aren't less than the legal minimum. So, what exactly is that legal minimum? Well, if your company does not have a formal collective bargaining agreement or a specific company retirement plan, the law steps in. It mandates a retirement pay equivalent to 22.5 days of salary for every single year of service.
And here is exactly how the law calculates that 22.5 figure. It's actually a really precise mathematical formula. It combines 15 days, which represents a half-month salary, plus 5 days, which is the cash equivalent of your service incentive leave, plus 2.5 days, which represents 1/12 of your 13th month pay. You add them all up, 15 plus 5 plus 2.5, and you get 22.5 days of pay for every year you dedicated to that company. It is absolutely crucial to know exactly what you are owed.
Well, we have certainly covered a lot of ground today, haven't we? From the strict twin notice rules of termination all the way to the hard math of your retirement payout. The employment life cycle is governed by this incredibly precise balance of management prerogatives and worker protections. So I want to leave you with this final provocative thought. If your job truly is a constitutional property right, are you doing enough to protect your investment in it? Understand your rights, understand the rules of the corporate breakup, and make sure that when the time comes to finally exit, you get exactly what you've earned. Thanks so much for joining me on this explainer, and keep learning.